392. United States reports. Page 1. June 10th, 1968. The Fourth Amendment hits the street. Cleveland streets in 63. Detective McFadden watching carefully. Terry and Chilton pacing the block. Window, corner, confer, then walk back to the glass, then back once more, studying the same downtown store. Each act alone might look innocent, but facts together show intent. A third man joins and walks away. They meet him again farther down that day. McFadden thinks they're casing a score, planning a robbery behind that door. Not just instinct, not just a guess. The Constitution demands something less than probable cause, but more than a hunch. Facts and inference, that's the punch. Specific and articulable. Say what you saw, make it reasonable. Crime may be a foot that justifies the stop. Brief investigation, know where it stops. But a stop is not a frisk. They are not the same. Two separate questions, remember the name. Terry versus Ohio, draw the legal line. Reasonable suspicion, objective every time. More than a hunch, less than probable cause. More than a hunch, Fourth Amendment law. McFadden approaches, identifies the badge, asks for the names, then evaluates the facts. The answers come back mumbled and low, but that alone is not the whole show. He believed the robbery might soon ignite a violent offense, a weapon in sight. He turned Terry around, patted outside, a limited search for the safety divide. Felt the hard shape in the overcoat, reached inside where the weapon was stowed. A 38 revolver came into view. Chilton carried another one too. Cats had none, so the search went no more. Safety was the purpose, not an evidence tour. The stop is a seizure, the frisk is a search. Both fall under the Fourth Amendment's horn. The stop is a seizure, the frisk is a search. Both fall under the Fourth Amendment's words. The stop is a seizure, the frisk is a search. Both fall under the Fourth Amendment's words. The court weighs safety against privacy and judge the content for reasonability. Specific and articulable. Say what you saw, make it reasonable. Crime may be a foot that justifies the stop. Brief investigation, know where it stops. But a stop's not a frisk. They are not the same. Two separate questions, remember the name. Terry versus Ohio, draw the legal line. Reasonable suspicion, objective every time. Stop, specific facts. Stop, tell me what they mean. Stop, rational inference, not some damn feeling you cannot explain. Frisk needs its own justification. Frisk, armed and dangerous. Frisk, protection of the officer, limited by necessity. Nothing more, nothing less. Nothing less, nothing less. Stop requires suspicion of crime. Frisk requires danger at the time. Stop requires suspicion of crime. Frisk requires danger at the time. Time at the time. Would a reasonable officer knowing what you knew see criminal activity coming into view? Could the person be armed? Could the danger be real? Can you state the facts behind what you feel? Judge the moment, not what came after. Right, every detail, every relevant factor. Experience matters, but experience must connect.
Observe facts to the threat you suspect. S, specific and articulable. D, temporary detention. O, objective evaluation. P, possible crime under investigation. F, Frisk requires separate facts. R, reasonably armed and dangerous. I, intrusion strictly limited. Frisk D is the purpose. K, keep this dog tied to the thread.
Specific and articulable. Say what you saw, make it reasonable. Crime may be a foot that justifies the stop. Confirm or dispel it, know when to stop. But a stop is not a frisk. Burn that in your brain. Suspicion of a weapon must support that second claim. Terry versus Ohio,
392 US 1.
the modern stop and frisk doctrine, that is where it begun.
More than a hunch, less than probable cause. Specific facts, objective cause. Brief detention, investigate the crime. Armed and dangerous, then the frisk may be justified. Weapons, not evidence. Safety defines the scope. State what you knew and never rely on hope. Stop and frisk. 2 questions, not 1.